Thank you, Justice Koteshwar Singh. Mine is the last speech between you and lunch. So I'll try to be brief, but then there are certain concepts I wish to place before you. Friends, when we started sending invites to all of you to attend this convention, there are certain developments in the world which had not yet taken place. We conceived this convention last year and sent you save the date around July and August. The world changed in many ways after November and in the beginning of this new year. Earlier, we used to use a term that we are at crossroads. I will use a slightly different term without elaborating it much, because all of you understand. The world is today at a T-junction. There is a dead end. You go to right or you go to left. But ultimately, if we don't uphold the core values of humanism and fairness, whether it is right or left, it is again a dead end. And one more fundamental thing I wish to point out. When we talk about rule of law, we cannot disassociate it completely from politics or geopolitics. And that is where my strong feeling is that if in global geopolitics, member states, big nations, small nations are agreeing to negotiations which the people can see, uphold none of the basic values and conventions, are purely transactional. So it is not merely a question of international rule of law or international economic governance. It becomes a fundamental channel to the faith and belief in the domestic rule of law. Because when you say the states and governments agreeing to negotiations which may not fully protect, they may not agree in normal times, it undermines faith and trust in the rule of law, even domestically. That's why we stand at a very critical point in history, but we also know that this may be a passing moment in the long tide of history. That is why this convention wishes to concentrate not on what is going on right now, but how these structures should be there for the long term to sustain global economic governance. I will not go into the factors of the rule of law. Many erudite speakers have explained them. But when we try to incorporate them into global economic governance, we look at predictability, which means clear, stable, and consistent rules are applied in economic policies and in international economic frameworks. And there is an element of equality, which means fair treatment of all states and actors, regardless of their economic power. Then comes accountability, because ultimately, whatever we can perceive today as constituting international economic governance, that is run through international institutions, which are primarily the outcome of a post-Second World War system, which was erected to maintain a status quo to prevent wars. But was it created for the times of today, when even in United Nations we have gone forward with the concepts of Sustainable Development Goals. We have gone forward with the conception of ESG. We are now working on these progressive global instruments, which, in my opinion, are based on the core values and principles of rule of law itself, because they try to promote sustainability, they try to promote justice, they try to provide fairness in how things are balanced between the rich and the poor, how in climate justice, climate finance, and even economic bailout packages, how the instruments are structured to be fair and equitable. So that is why this discussion on the rule of law being the basis of global economic instruments is something which should try to understand in a holistic and wholesome context. When I talk about the world on T-junction, it is this year's development. But just look at it. World Trade Organization, which was created to bring fairness in international trade through instruments like most favored nation treatment, non-discrimination, which are all core principles of the rule of law, is dysfunctional because there is a complete paralysis in its dispute settlement system from 2019. So it was not something brought in by COVID, it was before COVID. It is a paralysis which is enforced, and it is a big body blow to the kind of globalized world economic relationships we were imagining and we got used to. Now, the other instruments, because the world, the institutions have been created to support the weak, support those who are under crisis. And those institutions are IMF and World Bank. We have a topic on debt restructuring, sovereign debt restructuring here. But we must, as legal scholars, look into the aspects that how these organizations have performed, how they have lived up to the principles of rule of law in terms of consistency, in terms of fairness, in applying conditionalities, in making prescriptions. Then again, international investment law, India has cancelled a lot of bilateral investment treaties because how the rights of communities, environmental concerns, and other overriding concerns are to be looked at, while you also look at the enforceable rights for investors. And here I have a personal opinion, all may not agree. According to me, as a very basic economic concept, the profit is in direct proportion to risk an entrepreneur takes. When investors go to developing countries and emerging markets, they go there, they make their investments, private enterprises, not for granting any development assistance, but to make profit. And profit also at a scale which is not available in their home jurisdictions, where you have returns 2%, 5%, 7% at the most, being very, very healthy. But you go to developing countries looking for returns over 20%. So you are, by this huge margin, by this huge prospect of economic returns and profit, you are taking a calculated risk. But you also want a double cover. I should take a risk but my risk should be protected by legal instruments which interfere, according to me, in the normal setting of economic relations. So that's why one of the aspects I want to pose before this assembly is to think about investment protection. One, in the grading, where it is most extreme, that due to a regulatory change, entire investment is appropriated, or where due to various sovereign actions which are necessary for protecting the domestic interest of the communities who own the natural resources, who are traditional owners of such natural resources, which now the investment wants to develop and exploit commercially. So if certain thing is done through interference of courts, through interference of public outcry, in terms of giving some share to such communities while these profits are made. So whether that should result in a breach of an investment protection treaty, and the state which is inviting investment so that the economic standards can be improved, instead suffers a huge damage in terms of international awards. So this is one basic economic principle and impulse which we have to balance. So I think this is an aspect of international economic governance. Just to give you a little idea, I am talking about IMF conditionalities and the rule of law. If you look at various phases of IMF's working, you will find that IMF conditionalities vary across time and regions, and that undermines the core principle of consistency. Developing countries face stricter austerity measures. We can look at Asian currency crisis of 1997 and in Argentina in 2001, and we can compare it with Eurozone crisis in Greece of 2010 and what has happened recently in Ghana and Zambia. Indonesia, in 1997, 16 banks were closed abruptly on the basis of recommendations and as part of the bailout package. Subsidy cuts. It led to riots and deep social crisis, which undermined the rule of law in Indonesia while offering a hand of help. In Argentina, the rigid austerity measures led to social unrest and to a further default because there were no conditions existing to support those recommendations. The same thing has nearly happened in Ghana and Zambia. So that is why we want to discuss here that how these recommendations and these packages by the international organizations which govern the international economic frameworks take shape. And as members of legal community, we must be able to make suggestions and concept papers to ensure that these frameworks are wholesome. In fact, one of the greatest living philosophers Noam Chomsky, has said, these institutions, IMF, World Bank, WTO, are instruments of power, not of democracy. Their decision making is secretive, their policy is unaccountable, and their impact devastating on populations with no voice in their design. And that is where we say that the core principles of international economic governance must be informed, must be posited in these policies, that is predictability, equality, accountability, transparency, and inclusiveness. Friends, we are short of time, and I want to just make a reference to two of the Indian economists who have given their ideas on international economic governance. One is Professor Jagdish Bhagwati. He says globalization's critics have a point when they argue that the system has often been rigged against the poor, but the solution is to reform it, not to destroy it. And Professor Amartya Sen, the Nobel laureate, has said globalization is not intrinsically good or bad. What matters is how it is governed and whether the benefits are shared and the burdens justly distributed. So I think if we are able to identify these principles and we are able to act as legal profession, as advisors, to push these, as bar associations, to push these ideas, we will be contributing a lot, because otherwise, as again Noam Chomsky has said, that because lawyers must play a role as well, because IMF economists are like medieval doctors. If the patient dies, they say, well, we applied the leeches correctly, the medicine was right, the patient just failed us. Global population, especially in global south, is not a patient we should fail. Thank you very much.
Thank you so much, Mr. Prashant Kumar.